change from what happened 2 years ago in 2008 is some grand concern about the issue of undocumented immigration and some hostility toward immigrants. Now, there's undoubtedly some truth to that. But those pundits will ignore the fact that part of the outcome may instead relate to our continuing to live in an era of great economic uncertainty, with a recession with an end not yet in sight. And we know that regrettably our history in this country has been in times of economic insecurity. We too often look for scapegoats and find the appropriate scapegoats in our immigrant population. But the pundits will not talk about that. They will also ignore that if the outcome is what is predicted, that part of that is likely a reaction to a paralyzed policy-making apparatus in Washington, D.C. The paralysis that has prevented us for over a decade from enacting the kind of comprehensive, progressive immigration reform that we have debated and needed for so long in this country. Pundits will also ignore that a part of that outcome may be attributable to frustration. Frustration that when something significant is achieved legislatively, it immediately becomes controversial and subject to challenge. Pundits will instead, as I said, assert that the outcome relates to hostility toward undocumented immigrants. Now, part of that will be true because, as you all know, there are too many candidates for elected office and elected officials who have chosen to tie their political campaigns this season to a pledge publicly announced with great fanfare that they intend to support a replication of Arizona's SB 1070 in their own jurisdiction. That should be a matter of grave concern to all of us. Not because of the outcome of the elections, not because of the likelihood that some of those proposals will become true, but because it means that we are in the midst of a campaign whose central feature seems to be a willingness on the part of too many elected officials and wannabe elected officials to defy our constitutional principles. That is a constitutional crisis. It's a crisis that was precipitated by Governor Jan Brewer of Arizona when, at the end of April, she signed Senate Bill 1070. Now, this is a bill that you've heard about in the media, maybe read about, maybe even read some of the provisions. But let me reacquaint you with the monstrosity of this proposal, which has not taken effect as a result of the timely intervention of federal Judge Susan Bolton, who issued a preliminary injunction before the end of July, the intended implementation date of SB 1070, that barred the most egregious provisions of that law from being implemented. In a moment, I'll explain why she reached that decision. But to reacquaint you with the major features of SB 1070, were it actually to be implemented, SB 1070 would have required every law enforcement official in the state of Arizona to determine in every contact with any person, whether a victim of a crime, whether a witness to a crime, or someone being detained for some other purpose, in every contact, every Arizona law enforcement agent would have to determine if he or she had a reasonable suspicion, quote unquote, that that individual was undocumented. If an Arizona police officer had such a suspicion, he or she would be required to attempt to verify that individual's status, and if they could not verify it, would have to detain the individual, potentially arrest them, potentially subject that individual to prosecution. Prosecution under a new state crime, also created by SB 1070, a new state crime that makes it unlawful to be undocumented and present in Arizona. In addition, SB 1070 would have required permitted law enforcement agents to, without warrant, without any review by a judge or grand jury, without any warrant, to arrest anyone who that law enforcement official concluded had committed an act that would render that individual deportable or removable from this country. To explain further, what that means is that every law enforcement official in Arizona would be empowered to arrest immigrants who, on the basis of absolutely no training in a very complicated area of law, immigration, on the basis of no training whatsoever, to arrest any immigrant who they believe to have committed an act that would render that person removable or deportable from this country. Those are the most well-known provisions of SB 1070, and they are among the provisions that were enjoined by Judge Bolton. To explain why this has precipitated the constitutional crisis that I mentioned earlier, I should explain why Judge Bolton reached her reasonable and predictable decision. See, even before Governor Brewer signed SB 1070, she was advised by many, on both sides of the issue, that in all likelihood the law could never take effect, because it ran directly against a long-standing, well-established constitutional principle, an eminently logical principle, which is that in our country only one government, the federal government, has the right and authority to regulate immigration. Now, this is a well-established legal principle. It goes back 220 plus years, because to find the origins of this principle, you have to go back to the ratification of the Constitution. As you will recall, the Constitution followed a failed experiment under the Articles of Confederation, which is a loose alliance of independent states in the 18th century. Rejecting that failed experiment, we ratified the Constitution and created one nation with a federal government with central authority. By doing that, we adopted as a bedrock principle of this nation that only the federal government can regulate immigration. As I said, it's eminently logical if you think about it. If Arizona were allowed to have its own immigration laws, and California its own, and New York its own, and Virginia its own immigration laws, we would cease to be one nation. We would become 50 different nations, each with their own immigration laws and regulations. Specifically, their own laws about who's allowed to enter, to stay, and the conditions under which they are allowed to stay. But we are one country. We have for well over a century and a half referred grammatically to the United States in the singular. The United States is a great nation, not the United States are great nations. This is an essential attribute of national unity, is an essential attribute of being a nation. And it is that long-standing principle that Arizona and SB 1070 directly confronted and defied. In the very first section of that law, the state of Arizona announces its intention to adopt its own immigration policy. They even gave it a name. They call it attrition through enforcement. Now, to explain what that means, it means that Arizona's immigration policy is to make life so difficult, so horrifically unlivable, that people will decide on their own to leave the state of Arizona. Now, that inhumane policy is not the policy of the United States. And our Constitution provides a vehicle for Arizona, should it disagree with what the federal government is doing, to change federal policy. That vehicle is to use Arizona's representatives in the House and the Senate to advocate for a change. There is no provision in our Constitution for defying constitutional principle, for defying federal supremacy in the area of immigration, simply to precipitate a battle that might change policy. But not content to finish there, SB 1070 also violates other long-standing constitutional principles. Let me mention two. First, you have heard that SB 1070 not only invites, but mandates racial profiling. And that is certainly true. Let me explain why. I mentioned previously that every law enforcement agent would have to decide if he or she had a reasonable suspicion that anyone they came into contact with was undocumented. Well, how would they arrive at that reasonable suspicion? What we do know is that being undocumented and determining if you suspect someone of being undocumented is wholly different from what law enforcement agents usually do. Ordinarily, they are enforcing conceal evidence of the act. Those are all acts after the criminal act in furtherance of a criminal scheme. But in the case of the undocumented, the action, the act that renders someone undocumented, whether it's crossing the border without inspection or overstaying a visa, those acts are years ago, in some cases decades ago. So this is different from what police officers ordinarily do. This is effectively a status crime. How do you arrive at a reasonable suspicion that someone has a particular status? You're forced to rely on appearance. No actions on appearance. And we know that the appearance attributes that Arizona law enforcement agents are the ones that basically fit the stereotype of who are the undocumented. That means race, that means national origin, that means language, that means accent, that means other attributes of appearance that are linked to those bases. This is the kind of racial profiling that is mandated by SB 1070. And yet this kind of racial profiling directly confronts and defies a principle established at least a half a century ago when the Supreme Court determined in Brown versus Board of Education that that kind of racial discrimination by government agents is not permitted. And so Arizona, in enacting SB 1070, also defied that long-standing equal protection constitutional principle. But in another provision of SB 1070, not ordinarily talked about, Arizona directly defies the First Amendment and its protections of free speech by saying that for the undocumented and the undocumented alone, there is a prohibition from expressing a certain kind of speech, namely your interest in obtaining employment. That directly confronts long-standing law under our First Amendment, directly defies long-standing precedent that says, first of all, you cannot single out a particular group of people to restrict their speech. That you, second of all, cannot restrict a particular category of speech, soliciting employment. And that government should not engage in prior restraint of speech. SB 1070 violates all of those principles. But what we know also in Arizona is that Governor Brewer, Senator Russell Pierce, the state senator who authored SB 1070, are not finished. Russell Pierce has already announced his intention to reintroduce in 2011 and seek enactment of a bill that he has introduced year after year, a bill that directly defies another constitutional principle, this one in the area of education. He intends to seek the enactment of a bill that would charge tuition in public school from kindergarten through 12th grade, would charge tuition for any child who is undocumented. Now that is a notion that was rejected solidly 28 years ago in a case called Plyler versus Doe, where the Supreme Court was confronted by a similar law in Texas that allowed the charging of tuition, and the Supreme Court concluded that under our Equal Protection Clause of the 14th Amendment of the Constitution, you may not charge tuition or bar enrollment to any child from kindergarten through 12th grade on the basis of immigration status. But Russell Pierce has announced his intention to defy that 28-year-old principle.